Zoning Board of Appeals. I would ask that and I am going to call this Zoning Board of Appeals meeting to order at 7:40 p.m. on Thursday, May 26th. I'll ask that my colleagues introduce themselves, starting at my right.
Good evening. Ron Mostello.
Norma Dolan.
John Calogero.
Russell Tompkins.
On the agenda for this evening, we have the Cornerstone interpretation. This is an administrative review. Have all of the adjoining property owners been notified and
Yes.
fees paid?
Yes.
Great. The meeting will be recorded and broadcast this evening. To start with, I want to give just a little bit of an overview and kind of an explanation of the Zoning Board of Appeals, what some of our duties and responsibilities are, and how that specifically relates to this evening. So part of our duties of the Zoning Board of Appeals, one of them is called administrative review. And as part of that, what happens is if an official makes a decision or determination, which in this case would be the zoning administrator, about a particular item, and there's someone, it could be a member of the community, a member of the town board, that questions that or disagrees with it, they can ask the zoning board to conduct what's called an administrative review. And in that process, we take a look at all of the information that the zoning administrator looked at. We have the privilege of receiving, a packet with much information in it to review. We take a look at the zoning law, and then we come up with our own decision essentially based on that. And in the section of the code 250-98, subsection 3, it said the Zoning Board of Appeals may reverse or affirm wholly or partially, or may modify the order, requirement, decision, or determination appealed from, and shall make such orders, requirements, decisions, or determinations as in its opinion ought to be maintained, to be made. To that end, shall have all the powers of the officer from which the appeal is taken. So in other words, what we decide is the next step of final. Of course, if there is a continued disagreement, then that would go to an Article 78. But right now, specifically what we've been asked to do, or how this came about, was and I'm going to kind of take from this, which is a very thorough packet from the neighbors who have concerns about the zoning administrator's determination. And so to kind of summarize this, and this is what has brought about this meeting this evening. It says this firm represents certain property owners of the town of Clinton in regards to this application for review of an administrative decision or request for an interpretation under section 250-31 and 250-81 of the town code. And going to the specific appeal, our appeal is timely and seeks review of an administrative decision of the town enforcement official made on or about April 1st, 2022. And essentially what that determination was is, no, go to that. Was the determination that the zoning administrator made at that time. He said, "It is my determination that the increase in patient beds to its current capacity of 99 is not an expansion of the pre-existing non-conforming use of the site as an ACF under section 250-81 of the town code." And basically, so that was a determination that the zoning administrator made, and the group of the neighbors essentially are saying that they disagree, and the disagreement comes to, and this is found in the letter from Vanderwater and Vanderwater, which basically says that the code does not allow for expansion of a non-conforming use, and The specific section, which is just what I cited or mentioned, is the town code provides that a legal existing non-conforming use shall not be enlarged or extended or placed on a different portion of the lot or parcel of land occupied by such use on the effective date of this chapter, except as provided in this article. And then the comment, the increase in the number of residents and change in the type of residence is a clear increase in the non-conforming use. So, and again, the packet's very helpful that we have. It lists, kind of the history of Cornerstone with the different certificates of occupancy, many letters from, people that have been to Cornerstone and how it's helped them. We have also some, concerns from the neighbors. So basically, this packet that we have to review is saying that there is a disagreement with how the neighbors view the decision made from the zoning enforcement officer. And of course, we have a packet here, more information from Zarin and Steinman, which I believe Jody Cross is here, that essentially says that they agree with what what the zoning administrator made. So I just want to bring this to focus of what we're doing. We're not saying that something can happen or can't happen. We're specifically looking at that letter that the zoning administrator wrote, and we have to review all of that and make a decision, a determination on right, wrong, in part, in full, and that will happen. So right now, what we're going to do is hear from Kyle Bennett to share some comments, and then Jody Cross, and then we will open this up for, again, this is the public's opportunity to share. I would ask, again, there are several people here. Having worked through many of these meetings, we sometimes hear the same thing in great detail over and over. Just please keep in mind that we're here, all of us, we kind of sometimes joke around that we get paid twice as much a year because this is a volunteer for us, and we're happy to do this. We're here to be a service to the community. And we would just ask that if you hear your neighbor say something that's the exact same thing, and you're like, I totally agree, we want to know what you think. But if you're like, what John Smith just said, I totally agree with that. And that's, those are kind of my comments. And so that way it would just help all of us. We want to know, we want you to feel that you're heard, and any concerns that you have, we want to hear that. Again, just please also keep in mind that we are doing an administrative review of that one letter. So if it pertains to that, then please help us. But if there's something else, this may not be the venue. And if I cut you off or if I redirect you, please don't be offended. We have a lot of people here, and we want to hear from everyone. We want everyone that's here that wants to share to have that opportunity. If we can't get to everyone this evening, we'll hear from you next month. Again, we're here to be of service to you. So with that, are there any other comments from the board? All right, so Kyle, if you would come up, and if you need us, however is good for you.
Do I have to use the microphone?
Can everyone hear? It's entirely up to you.
No, it's good to, this way you put it on the.
All right, yeah, so yes,
Yeah.
use the microphone, or you can move it around however is convenient.
Yeah.
It falls out. Be very careful.
Can it reach though?
Yeah, I think it's got room. All right. Thank you very much. I appreciate it. That was an excellent introduction and summation on how this process goes. So I appreciate that, Mr. Chair, and all the members here of the board. My name is Kyle Barnett. I'm with the law firm of Vandewater and Vandewater. And as the chair aptly indicated previously, I represent quite a few neighbors of the Cornerstone project that have some concerns regarding the expansion. So what I'd like to do is, and I know there's folks here that want to speak, and I have provided a pretty comprehensive letter. I know you've received a letter from Mr. Zarin and Ms. Cross, and I also have another letter I'm going to submit in reply to that provides a bit more detail. This way I don't have to consume the entire evening sort of going over each and every fact. But of course, when I'm done and after Ms. Cross speaks and anybody else, if there's any questions, I'm happy to answer them. I would certainly encourage you, if there's any confusion, questions, or concerns, please feel free to ask those of me before we leave this evening, or even if it's subsequent to the meeting, that there's some follow-up necessary. I encourage that from all the members of the zoning board. So just to kind of start from the general and kind of work through this, I'm going to try to do it somewhat systematically. As this board's probably aware, there in the law, when there is a certain use of a particular piece of property, such as in this case where previously was Rhinebeck Lodge, where they're using that particular piece of property for whatever that use may be. And subsequent to that, after that, at some point in time, and this happened a lot throughout the state of New York in the 70s and 80s, that particular town adopts a zoning code. Well, what the courts have long since held is that it would be unfair to the owner of that property who's using that property to be penalized if the zoning code that comes into place suddenly prohibits that particular use. And the common phrase that everybody knows, even non-lawyers, is that it's called grandfathered, right? They're grandfathered in. And if they're grandfathered in, the legal term is, right, prior non-conforming use or illegal non-conforming use. And they're entitled to continue that use up until, unless there's what's called an abandonment or a cessation of the use, as either defined by the code and if not by the law. However, there are some restrictions, and why there are restrictions on grandfathering makes sense to most folks, and it's also provided for in the law. And those restrictions are, look, it is the public policy of the state and of this town too, as evidenced in the town code, to at some point in time see the elimination of non-conforming uses, right? That's the goal of the town code. It says it right in it. And that's actually the goal of many state courts that have interpreted that, acknowledge that as a legitimate, laudable goal, to see the elimination. So why that's important is because that it allows the town to provide certain restrictions upon the non-conforming use going forward. And I'm sorry if some of this stuff is repetitive, and I'm sure you're all familiar with it, but I just think it lays a good framework for where we're going. So as a result, it puts a limitation on things like enlargement of the non-conforming use or expansion of the non-conforming use, right? Because that's in derogation of what the actual intent of the code is, to allow for restrictions. So in this case, what happened was you have Rhinebeck Lodge, which provided rehabilitation services for alcohol, and there's a letter which you have in your packet from the prior owner, dated in '77, that says what we do is we provide alcohol support for the executive or for the certain people in the population. I'm paraphrasing her note. Forgive me if I don't get it all right. But basically, we do that, provide rehabilitation for alcohol, smoking, weight loss type of thing. One thing that she makes clear, and even in the subsequent statement, the prior owner, is that it's never going to be a medical facility or provide any type of medical type of services or support. And that's the use, essentially, that was in place when zoning was enacted, right? It was a rehabilitation center. Then what happened is, and subsequently it was grandfathered in as a prior non-conforming use. Thereafter, that use continued for quite some time, perhaps maybe even as much as 2 decades or so, in terms of just being a rehabilitation center. However, at some point, and it was shortly before, I believe, the Rhinebeck Lodge was sold to Cornerstone in the mid-90s. The facility received a certification to provide medical detox services, all right, which is obviously an entirely different use than what existed prior to that date in the mid-90s. And it's a use that in no way, shape, or form is permitted in the district that the lodge is located, which is a C district, which is conservation, agricultural, residential. You can't have a hospital and a medical facility in a C district. It's prohibited. Can't do it, unless it's a prior non-conforming use. But in this case, it wasn't, because it wasn't a use that was put in place when the zoning was enacted. So therefore, that is, and it's long since been held, an expansion. Yes, there's a case that's cited by Mr. Zarin. Yes, if you have a hospital or sanitarium, as it's sometimes called, right, and you provide certain medical services, maybe only a specific type of medical service, and then 10, 20 years later, you provide another type of medical service, well, that's okay, because they're all medical services. But what you can't do is say, I've got a farm full, a pre-existing use that's a farm full of pigs, and eventually start raising sheep. That you can't do if that's a non-conforming use. You have to stay within the confines of the use. Anything beyond that is an illegal expansion. And the cases on that are very clear. I've provided them in my packet, and I have some additional ones that I'll share with you. So the cases that I've seen so far that might suggest otherwise don't apply to a situation as the one I just described, where the use actually either changes or it adds a use that is completely unrelated to the prior use. And in this case, hospital, medical is clearly defined in the town code. In 1998, a former, I believe it was Cookingham, former ZEO of the town, zoning enforcement officer, finally came up with a designation of what Cornerstone was, and that's an alternative care facility. That definition is found in the town code. In the Cosenza determination, which is what's subject to the appeal, Cosenza says it also falls underneath the subcategory of a rehabilitation services facility, I believe. And that's also defined in the town code. But nowhere in those definitions of either an ACF or an RSF, which we don't dispute is what the prior existing use is, does it allow for medical or hospitals. It doesn't. And detox, as aptly pointed out in both our papers prior and the submission we're going to make subsequent to this evening, detox is a medical procedure, completely different than the type of residential use that a rehabilitation center is. Detox is short, it requires medical support, and it requires medical assistance, whereas a rehabilitation does not. And nowhere in the definition of ACF or RC or the rehabilitation services is there anything that indicates medical support is permitted as part of that. So we now know that an ACF it does not include medical. We know that Cornerstone's designated an ACF, and we know that when it was grandfathered in, it did not provide medical services. As such, doing so now is an illegal expansion of the non-conforming use. And that's one of the issues we have with the determination. The Cosenza determination completely overlooks and simply says, well, this is what they were doing in 98, and therefore if that's what they were doing in 98, it's okay today. Well, the problem with that is 98, well, I don't know why 98 gets picked, because that's far after the zoning was enacted in this town. He had to go back and do an investigation as to what they were doing when when zoning came into effect. The ZEO failed to do that, and that's why that part of his determination is an error. The other issue that's an error is this: the expansion of the number of beds, right? So in this case, the ZEO says, well, the relying upon, I believe, it's unclear exactly how he comes up with this conclusion, but let me summarize it as best I can. The ZEO says the application to go from 66 beds to 99 beds is not an enlargement or an expansion of the use. and cites to, I believe, a Fenton letter, where Fenton, I guess, previously says, hey, you guys got to go get a special use permit and a site plan approval to do any kind of enlargement. And Fenton's correct. If you're an ACF, regardless of where you're located, whether you're a prior non-conforming use, if for some reason you can accomplish it without violating the zoning law, or you're an ACF that's permitted within your particular zone, and you want to expand or enlarge, you have to get a site plan and special use permit. That is true. But what was overlooked is whether or not that is permitted when you're a prior non-conforming use. And that's what gets lost in the Cosenza letter. And for some reason, ZEO Fennel in 2005 holds that very same thing. It's in black and white and says Cornerstone cannot increase its bed size. For doing so would be an illegal expansion of a non-conforming use. Says it right there. Cosenza completely ignores the precedent, doesn't even acknowledge it or explain why he's ignoring it. There's another problem, too, that Mr. Cosenza does with his determination. And that is, and this is going to require me to take a look at something here, and this is going to also respond to some comments that I believe I saw in Mr. Zarin's letter. And that is that the increase in the intensity. See, what happens is, and there's cases cited in the Zarin letter, which are correctly cited and correctly reference the particular cases that say increasing in intensity is not considered an enlargement or an expansion of a non-conforming use. But what those cases don't address, and what was missed here, also missed by Mr. Cosenza as well, is that those cases don't address a situation where the town code specifically limits the intensity of the use, which a town code may, as held by the second department. If your town code says that this provision is intended to limit the intensity of the use, then that non-conforming use is simply not permitted to ignore that and increase the intensity or the volume. There's no dispute here, by the way, that going from 66, a 50% increase in population is a more intense use. That's not a dispute. I think everybody can agree to that. But as is, by the way, starting and providing medical services, that would also is an increase in the intensity for obvious reasons. But the question becomes is, does your town code prohibit that? Because if the town code prohibits that, it can't be done. If the town code doesn't, well, then I see where someone can make a fair argument to the contrary. But if you take a look under the particular applicable code, and Kat, can you bring that one up? And for some reason, Mr. Cosenza skips right over it and simply goes to a section dealing with the enlargement, expanding non-conforming uses on land, which has nothing to do with what we're talking about. Yeah, that's 250-80 up. You gotta, it's hidden. There you go. Yeah, 250-80 sub B, right? The intent of this article is to limit, by not increasing non-conforming uses, and to eliminate such uses as speedily as possible, so the town is interested in getting rid of this use, right? But at the same time alleviate the economic hardship to an existing non-conforming use, which of course it's required to do, by allowing it to continue at its existing level of intensity. So right there in black and white, it made it very clear that the intention of the statute of non-conforming uses is to continue at the existing level of intensity. And courts have repeatedly held that restrictions placed upon non-conforming uses are perfectly legitimate. You don't have to do them, but if you do, they must be abided by. And right there, the code prohibits an expansion or an appreciation of intensity on a non-conforming use. Now, for some reason, like I said, Mr. Cosenza completely blows by that one, blows by Mr. Fennell's prior determination that the increase in the beds would be an illegal expansion of the non-conforming use, and then simply goes to the section where you're dealing with vacant land, which of course obviously we're not. So that's the other issue you have. You have two issues in terms of both the providing of additional services and uses that weren't there prior to the zoning, and an increase in intensity in violation of the zoning code. I also want to just mention briefly, as we have, the issue regarding the objection to the type of population, which was referenced both in our appeal and I go into it in more detail in our response, it's not meant to be discriminatory. The type of the population that's changing is the difference between the patients that were seen under rehabilitation and the ones that would be seen in terms of providing detox. Those are two totally different needs, and going to represent different folks who are going to require that. Okay, I do want to address briefly. I don't know if this was just a toss-in argument or what, but I'll mention it, and it's also in my letter. There was an argument that was made that our appeal is not timely. That's not true. It's based upon the argument that if all we're doing is appealing in other words, if the determination is simply a regurgitation of a prior determination, then the appeal should have been taken on the prior and not the latter. And the case that I believe is cited deals with a situation where there's a certificate of occupancy that got issued several years prior, and then a few years later, it gets reissued. Identical, totally identical. Clearly, that's not the case here. For starters, so the argument is the Fenton letter, the Cosenza letter is simply a regurgitation of the Fenton letter from 19. That's clearly not true. I mean, Cosenza, Fenton doesn't ever get into or even analyze the issue regarding whether or not the increase is an illegal expansion or this issue regarding the services provided at all. He doesn't get into it. And instead, what he focuses on is whether or not, which was applicable to the question that was being posed by the project sponsor, by Cornerstone, is whether they could increase their building size. Recall that they were looking to increase the facility at one point in time. That's what Fenton was focused on, was whether they could do that. Ironically, he came to the opinion, if you go get a site plan and special use permit, there's a certain increase you can do. Cosenza actually disagrees and says you can't increase the size of the building. So right there's a striking difference between the two. Cosenza gets into his interpretation as to whether or not the increase in intensity is permitted or not. Obviously says it is. Fenton never even addresses it. So maybe the Fenton letter is too ambiguous, maybe it's not, but it's clearly not the same decision, one following the other. Secondly, the Cosenza letter actually says to us, you may appeal this determination. So that's actually written in the letter for which we are appealing. And I guess if you were to turn this argument around, I'm sure it's not what the trap Cornerstone expected, but obviously, if Cornerstone disagreed with our ability to appeal that letter, they should have appealed Cosenza's determination that said we had the right to appeal within the 30 days, never did, so any argument on that regards would be untimely, right? So for those reasons alone, and again, I get in more detail in my letter, this appeal is obviously timely and should be heard, and I think if it isn't, or dismissed summarily, I think it would create some problems. So I appreciate it. Like I said, I know a lot of folks want to speak. I have some other items I may want to address, but I'd rather give you folks a chance to ask questions and get more specific into what we need to deal with. Thanks again
Great.
for your time and attention. I appreciate it.
Thank you, Kyle. Jody?
Sorry, just give me 1 second. Because I know that the screen is over your heads, we printed out copies of this.
Thank you.
Sorry,
Yeah.
my arms are short.
Yeah.
Can you reach that? All right. I need more photos, for sure. All right, thank you. Good evening, Jody Cross from Zarin and Steinmetz, here on behalf of Cornerstone. And I'm here tonight with Tom Puzo, the president and CEO, Jeff Onafather, the executive VP of Finance, Dave Bachner, the exec VP of Administration and Clinical Services, and Michael Purnell, the exec vice president. And I thank you for giving us the opportunity to speak. Obviously, as the property owner, we have a large stake in what happens tonight. As you know, we submit an extensive letter on these issues. I'm not going to go line by line through what we've done. I know there are a lot of people here. But we do need to hit on a few relevant points here. So the first issue is the timeliness issue that Mr. Barnett just mentioned. And it wasn't just a throw any argument and see what sticks type of argument. We truly believe, and we believe the case law supports the fact that this is not a timely appeal. So if you could just hit the space bar. Did that not work? So if you go to the second page of the handout, it's a side-by-side comparison of the two letters. And we went through a detailed chronology of everything leading up to this in our letters, so I'm just going to summarize. So former CEO Fenton first made a determination on March 6, 2021. He determined at that time the facility is a pre-existing non-conforming use. He determined that the facility was an alternate care facility, or an ACF. And he determined that an increase in resident population would be permitted so long as Cornerstone went to the planning board and got the proper approvals under 250-31B5. So, contrary to what the neighbors have argued, Mr. Fenton actually did make a determination that the increase in beds is not an increase or enlargement of the pre-existing non-conforming use. You can't on one hand say you could go get approval for it and not be saying, and therefore it's not impermissible. It just goes together. So, and then Mr. Fenton reiterated the same positions both in a violation notice in August of 2021 and in November of 2021. These are all in our submission. So April 1st, 2022, CEO Cosenza, he also made a determination. That one's on the right. He expressly references Mr. Fenton's determinations, all three of them, and he also concludes that the facility is a pre-existing non-conforming use, that the facility is an ACF, that the increase in resident population is permitted with planning board approval, and he expressly said that the increase in beds was not an impermissible enlargement of the nonconforming use. So side by side, these are the same arguments. There are no new conclusions in Mr. Cosenza's letter that aren't already within Mr. Fenton's letter. And the case law is clear that if there's a determination that merely reiterates, not word for word necessarily, but also in substance, and the cases use that word, it says either verbatim or in substance, the original decision would be appealable, and the new one, it does not create a new appealable document. So neighbors never appealed the Fenton decisions. So the question comes up, did they know about them? They were issued to us, so how did the public know? Other than the fact that we have reason to believe that they knew and that they had a part in getting the notice of violation issued, we don't have evidence of that, so that's just conjecture, I admit that. But the March 2022 letter from the neighbors to former building inspector Travis references the notice of violation, so clearly they were aware of it. And also, giving them benefit of the doubt, Cornerstone submitted an application to the planning board in November of 2021. And that application was for approval of the increase in the beds, and it was at Mr. Fenton's direction, and it attached Mr. Fenton's March 2021 letter. One of the neighbors who's here in opposition, one of the appellants, Ms. Maxinova, I'm sorry if I mispronounced your name, she was sitting on the planning board at that time. She recused herself, as she should have, from the application as a neighbor, but she certainly can't say she didn't know that there is this letter in there, since that's why the application was made. So even giving the benefit of the doubt, as late as November of 2021, the neighbors were aware of Mr. Fenton's letter, but they chose instead not to appeal that. Instead, they waited 4 months while Cornerstone's application was pending before the planning board, and then wrote a letter to the then building inspector, hoping to get a different result. And what they got was the Cosenza letter. There's a reason why there's a 30-day statute of limitations. It gives owners, such as Cornerstone, closure and finality when they get determinations. So here they are processing for 4 months, and lo and behold, here we are paused again. And we could get to the fact that we don't believe this pauses it, but that's really not for your board, that's for the planning board. It's not intended that, once there's a determination, you can't just keep asking the building inspector to reissue that determination and create a new appealable paper, because when does that stop? You have to, that's the point of a statute of limitations. So, again, we believe that the Cosenza letter is not an appealable document. This appeal is not timely, and this alone could be grounds for your dismissal, and you don't even have to go any further. But I also know you will. So I just want to get to the merits. We set out our arguments in the letter in great detail. And Mr. Chairman, thank you for your very good explanation of the letter, and Mr. Barnett, I appreciate yours as well. But from my reading, it really, the crux of the issue comes down to 2 questions. One, they argue that Cornerstone's increase in beds from 66 to 99 between 2001 and 2016 was an impermissible expansion of its nonconforming use. You've heard that. And for that reason, the planning board can't grant approval of the increase under 250-31B5. They also argue that there was an impermissible change in the types of services offered and the types of population. They're wrong. And we'll explain why they're wrong, and our letter explains why they're wrong, and representatives from Cornerstone will explain why that's wrong. So first I want to start, the board knows, and I'm sure your legal counsel will agree, that there are 2 really important legal issues here. The first is that a mere increase in volume of business or modernization of facilities does not constitute an enlargement of a nonconforming use. And the second issue is that zoning is concerned with the use of land, not the users. In other words, there's a plethora of case law out there that says you can't control internal business operations. So if you could just hit the space bar for a second. There you go. You just saw this before, and this is section 250-81A, which states that nonconforming uses may be continued so long as they're not enlarged or expanded. One more time, please. Thank you. There's not that many slides. I won't make you get up too much. Section 250, Section 250-31B5 says that Any ACF that increases its resident population, changes the type of population served, or expands the facilities must obtain approval from the planning board. That's why we have an application pending before the planning board at this time. So to explain why the neighbors are wrong, I just want to give you a little hypothetical. Courts have held that a gas station with 4 pumps can double the number of pumps they have, or dispensers they have, double the number of customers coming in, and even though that increases their business, that's not considered an intensification or an enlargement of the use. And that's because this mere increase in the business, just because I have more customers and I'm doing well business-wise, it's still a gas station. The use hasn't changed. So the very nature of Cornerstone's use has not changed. But what the zoning code can't do is dictate that the gas station can only sell a certain octane level of fuel, or that it can't sell diesel fuel. And if that same gas station, say, has a pre-existing non-conforming accessory repair garage, zoning can't mandate that only American cars are served but not European cars. They can't prohibit the gas station from upgrading or modernizing their facility to be able to service modern cars. I'm sure what they're working with in the computers and technology today is far different than when cars were being serviced in the 70s. That's not an expansion of a non-conforming use, and that's not controlled by zoning because that's the internal business operation. That's the users, not the use. The gas station use, the accessory garage, they stay the same. So when we speak about this increase in intensity, that is exactly what these cases talk about. And if you go to these cases, they're all provisions that say you can't enlarge or extend your non-conforming use or intensify them. It's the same words used all throughout. So I do believe that every case that we cited is absolutely on point. So why am I talking about a gas station when we're talking about a Cornerstone? So similar to that hypothetical of adding dispensers, Cornerstone added 33 beds between 2001 and 2016. It increased its business capacity, there's no question, for 33 extra beds, but the fundamental use as an ACF had not changed. If you could just, one more. So this is the definition of an ACF. And just, and as Mr. Barnett noted, we fall under the subtype as a rehabilitation services facility or an RSF. So I'm going to use those acronyms because it's a mouthful otherwise. So to summarize what the purpose is of an ACF or RSF, it's designed to improve the functioning and daily life skills of alcohol abusers and drug-dependent persons. That's the use. That's the definition. That's true whether it's 66 beds or 99 beds. Cornerstone and Rhinebeck before it were improving the functioning and daily life skills of alcohol abusers and drug-dependent persons. The increase in bed didn't impermissibly change that use. It stayed the same. And the law is clear on that point. So then next, the neighbors claim that the services provided have changed. You heard that whole explanation about detox and medical use, et cetera. Except the neighbors are wrong because Rhinebeck was doing detox. They attached a certification from OASIS, the regulating authority, New York State regulating authority, that specifically approved 8 beds for alcohol primary care program. And I've been told that that means detox. So they were doing that already. And in any event, whether it's detox or rehab, it falls under the definition of improving the functioning of the daily life skills of alcohol abusers and drug-dependent persons. It doesn't suddenly become a hospital because of how you're treating the patients, just like it doesn't change the use of a garage if you're suddenly using computers instead of wrenches. So in any event, for the purposes of zoning, what's important here is this definition. It's not what OASIS certified. OASIS can regulate the use, and OASIS does regulate the use, the business operations. That's not under zoning, though. Zoning is, do we fall under this definition? Have we always fallen under this definition? We have. The use was an ACF RSF under Rhinebeck Lodge. It was an ACF RSF when it was purchased by Cornerstone in '98, and it remains one today. So while over the years, the practices and how to treat and how to improve the functioning of alcohol abusers and drug-dependent persons may have changed or evolved, it doesn't change the use itself for purposes of zoning. And it doesn't matter if you go back to 1970 and find that they didn't do detox then, because again, it falls under the same definition. Also, the population hasn't changed. Whether someone is getting detox or someone is getting rehab, they are again, and I hate to repeat myself, but it is an important point, they are a person who is an alcohol abuser, drug-dependent person, chemical dependency, it's all the same thing. Whether you get detox or rehab, you're still the same person. I also want to point out that there was a lot of talk in the letter and also at the planning board, if you happen to watch that, about suddenly we're treating people from the criminal justice system. And that has to do with CARF accreditation. Just to put it aside, CARF accreditation is just you are a great facility, period. It doesn't regulate anything. It has nothing to do with who attends the service, who gets services from the use. It's just being misunderstood as to what it is. But, and also, it's important to note that by law, Cornerstone cannot discriminate against people coming to, who need their services based upon their background. Once they get there, if they are an alcohol abuser or a drug-dependent person, they are entitled to service, and Cornerstone can't turn them away just because they came from the criminal justice system, they came from the street, they came from Putnam County. So, I think I spoke enough. And I'll stop talking, almost, in a minute. But I respectfully refer the board to our letter for fuller exposition of all of these arguments and some of the other red herring arguments that were raised, such as the fact that, yes, we can go before a planning board to get a special permit to cure an alleged violation, and whatever our CO says doesn't prohibit us from showing the planning board a site plan to approve and the existing conditions. But before I turn the mic over, I just want to note one thing. Cornerstone hopes that this appeal is decided quickly. They would love for it to be done tonight. They have an application pending before the planning board, and although the law is clear that an appeal here by the neighbors doesn't stay the proceedings in the planning board, we are concerned that there's going to be undue delay and uncertainty to Cornerstone and the people they treat. And that's why the legislative intent, going back to the timeliness argument, is so important. They waited 30 days after Mr. Fenton issued his determination, long after that, but here they are, 4 months into their application, they suddenly get, the brakes put on, not to go back to my automobile analogy. Cornerstone needs to be able to operate this laudable and very important use, and we ask that this board, at the end of tonight, close the hearing and either dismiss the appeal as untimely or uphold the determination and let Cornerstone go and serve the people of the community that need them so much. Thank you.
Thank you, Jody. Appreciate hearing from Jody and Kyle and their comments. As board members, we take note of all that we've heard. At this time, I'd like to make a motion to open the public hearing.
Second.
All in favor? So moved. At this time, I would like to hear from the public. Can I show by a raise of hands how many people would like to share comments? Okay. All right. I would just ask, again, this is why you're here and we're here principally this evening, to be able to hear your comments. Again, as a reminder, I would like you to be as concise and succinct as you can be to get to the point. And again, if someone else has shared the same thing, you can mention that, but we're looking for new information from you, so we would like that. So, and if you would please state your name when you start. So let's see, who do we have? Who would like to go ahead right here?
Good evening, and thank you for hearing me to speak this evening.
Sorry, I'm short. You might want to raise that.
I don't know how to raise it. I'll speak like this. My name is David Bachner, and I'm the Executive Vice President. How do you raise it? I just don't, I have no idea how. Michael, I have no idea. Oh, it goes on the bottom? Yeah, I'm not used to a lot of rock star. Clearly. Good. Yeah. Check. Sorry, guys. I don't do a lot of singing. Okay, here we go. My name is David Bachner. I'm the Executive Vice President of Administration and Clinical Services at Cornerstone. I've held that position for almost 15 years, but what I really am is a social worker at heart. I've been one for more than 30 years. It's been my life's work. Tonight, I want to correct some of the misinformation submitted to your board about the services provided by Cornerstone and the types of people we serve. In short, we are continuing to provide the same services to the same type of population that was provided by our predecessor, Rhinebeck Lodge for Successful Living, prior to our ownership. Going back 25 years, at the request of our New York State licensing agency, OASIS, Cornerstone was asked to take over the facility from Rhinebeck Lodge. Initially, Cornerstone managed the facility for a year and then took over ownership in June of 1998. At that time, Rhinebeck Lodge was certified by OASIS for 8 detox beds and 58 rehab beds. Under OASIS certifications, Cornerstone continued to provide care for patients in need by utilizing the same 66 beds which had been licensed and used by the Rhinebeck Lodge, except that when Cornerstone took over the ownership, we reduced the number of detox beds to 6, with 60 beds dedicated to rehab. This was done with OASIS oversight and approval. Cornerstone gradually increased the maximum number of beds between 2001 and 2006 to 96 beds. In 2016, that number was increased to the 99 that we have today. The point being is that for 16 years, the number of beds has essentially been the same. Each time Cornerstone increased bed capacity from 66 to the current 99, it did not do so on its own. Cornerstone went through a comprehensive process with OASIS and Dutchess County Department of Behavioral and Community Health, and were duly certified for the 99 beds. To the extent that the planning board approval was required under the zoning code, there was never any intent to ignore that requirement. I will leave the legal arguments to our attorneys, but what's important is that in response to Mr. Fenton's directives in 2021, we now have a planning board application pending. Today, 6 of the beds still provide withdrawal services or detox, and the remaining 93 are for patients undergoing rehab. The neighbors believe that Cornerstone has impermissibly expanded the type of service it provides and that were historically provided by Rhinebeck Lodge, adding detox services to the mix. In other words, the neighbors insist that Rhinebeck Lodge only provided rehab services and not detox. This is categorically false. Again, when we took over ownership, we assumed an 8-bed detox that was pre-existing, as well as 58 beds for rehab. As our attorneys noted in Cornerstone's written submission, Rhinebeck Lodge's certification for 8 detox beds is included in the papers submitted to you by the neighbors, specifically the operating certificate, Almaday Corporation, DBA, the Rhinebeck Lodge for Successful Living, to, quote, operate an alcohol primary care program. As Jody aptly said, alcohol primary care program is a detox program. Certainly, over the 40 years people have been treated, treatment methods have evolved, but the types of services offered at the facility have stayed the same. In other words, Cornerstone provides the same rehabilitation and detox services just like they were provided by Rhinebeck Lodge. And more relevant to this proceeding, as our counsel mentioned, for 40 years this facility has been a treatment facility designed to improve the functioning and daily living skills of alcohol abusers and drug-dependent persons. It operated as an ACF, ISF prior to Cornerstone, and it continues to operate like that in the same vein today. The neighbors also argue we've changed the type of population we serve, which is also not true. For example, if the neighbors think Rhinebeck didn't treat people in need of detox services, they're wrong. But people who need detox services, just like people who need rehab, are the same type of population. People with substance and chemical dependency issues. Doesn't matter which service they receive because it doesn't change the type of population that we serve. Jody touched on CARF, but I want to say it again. CARF is the Commission on Accreditation of Rehabilitation Facilities. As noted on their website, quote, CARF accreditation signals a service provider's commitment to continually improving services, encouraging feedback, and serving the community. For some unknown reason, the neighbors think that CARF accreditation means that, for the first time, Cornerstone is taking in a new type of population that comes from the criminal justice system. That's not what CARF accreditation means. Our program certification comes from OASIS. CARF does not oversee or dictate any of our operations. In fact, we have always taken in any individual with substance or chemical dependency who is in need of our services. That includes working with the courts and divisions of parole and probation to provide treatment to individuals in the criminal justice system when appropriate. More importantly, our certification in Rhinebeck lodges before ours prohibits us from turning away people based on their criminal background. We have not changed the population we served. We have always and will continue to treat chemically dependent individuals who want to be happy, healthy, and substance-free. We submitted to this board a letter from OASIS discussing the tremendous need for the additional 33 beds. In the interest of time, I won't reiterate everything in that letter, but I respectfully refer all of you to our submission and OASIS's discussion regarding the unmet and increased demand for substance abuse treatment and the need for inpatient beds. To lose 33 beds at our facility would be a terrible injustice to those who are in need of our rehabilitation and detox services, causing unnecessary death in some cases. The opioid and fentanyl crises are continuing to plague our society. As the OASIS letter highlights, during the 12-month period ending in September of 2021, there was a 192% increase in fatal drug overdoses in Dutchess County alone. 192% increase. Community providers are also noticing a rise in cocaine use, and of course, the COVID pandemic has only exacerbated this situation. Almost done, sorry. As we all know, the past 2.5 years have been the most difficult time for healthcare due to this pandemic. Despite Cornerstone losing a great deal of money from operations in that 2.5-year period, we never laid off one employee, nor reduced employee benefits, or failed to make the necessary repairs to our plant. We stayed the course and provided quality services to as many patients as possible due to the commitment and dedication of our employees. During the pandemic, Cornerstone employees risked their lives and their families' lives by coming to work every day in a mask to make sure our patients were taken care of. As you can imagine, this was a very difficult thing to do. It takes a great deal of courage, dedication, and commitment to provide the quality of care that our patients so desperately needed during this very difficult and dangerous time. I'm privileged and humbled to be working with our Cornerstone staff. They truly personify the word hero. Members of the board, it is with utmost respect that I implore you to uphold the determination on appeal that repeated Code Enforcement Officer Fenton's conclusions in 2021. Cornerstone has not impermissibly expanded its non-conforming use, changed its population, or changed its services. Let us proceed before the planning board to memorialize the increase in beds and to let Cornerstone continue to serve this community and provide its necessary services unimpeded as we have been doing for the last 25 years. Thank you kindly.
Thank you, David.
Can I leave this with you?
Yes, yep. Yep. Okay, and so next, I'm sorry, can you state your name and where you're?
My name is Michael Purnell.
Okay, and then next I'd like to hear from one of the neighbors here.
Okay.
So, yeah, go ahead.
Check.
Yep.
Good evening. My name is Michael Purnell. I'm the Executive Vice President at Cornerstone of Rhinebeck. I'd like to thank you for giving me this opportunity to speak. I'm an LCSWR. I've worked in behavioral health for over 40 years, the last 30 in chemical dependency. I've been involved in the treatment of literally tens of thousands of people addicted to alcohol and drugs. I joined Cornerstone in 2008 and have watched with great pride The dedicated staff help people that desperately need the treatment we provide. In the past 12 months, 56% of all of our admissions have been from the upstate area. Daily, we have up to 35 local people working as staff, with far fewer in the evening, the overnights, and the weekends. And we don't have visitation to the campus. So the impact on local traffic patterns is minimal, particularly as staff start times are staggered. The locks on our doors are there to keep people out for the safety of our residents, not to keep people in. We monitor the patients throughout the day and night by taking attendance at each meal and each snack, and by doing bed checks every 2 hours overnights. We have 26 cameras, both inside and outside, which are constantly monitored. We cannot keep people against their will. Each discharging individual, however, leaves with an aftercare plan and is offered transportation. For us to do otherwise would not benefit the patient, the staff, the organization, or the community. The daily schedule is very intense and very structured. Group therapy, evidence-based treatments, specialty groups, and didactic presentations occur all day. There is also free time interspersed to do homework, for recreation, and for socialization. Chemically dependent individuals are typically unable to socialize without being under the influence. However, before a person can successfully reach and maintain recovery, they need to be able to socialize without using substances. And as we have all rediscovered over the past 2+ years of the pandemic lockdown, people do not do well when forced to isolate. We are social beings. We all need a social support network, but people with a substance use disorder must develop a strong one to remain alcohol and drug-free. What I would really like to take a moment to highlight is that the impact on the surrounding community as a result of the increase from 66 to 99 beds is imperceptible. In fact, although we have been operating with a maximum of 99 beds since 2016, our maximum beds increased to 96 as far back as 2006. We've had essentially the same size population for 16 years. Whatever impacts the neighbors are concerned about have not increased or intensified at any point in the recent past. Our use remains the same as it has always been, including going back to when it was Rhinebeck Lodge. There will be a few residents outside enjoying recreational activities. There will be cars arriving and leaving the property, and there will be delivery trucks, whether there are 66 or 99 beds. Except with 99, we have the capacity to treat more of the population who so desperately need us. I understand the dynamics of sound transmission at a lake. I've been outside at Cornerstone evenings and overnights on occasion. I've heard talking, music, the sounds of normal life traveling across the water from our neighbors, particularly during those seasons when the leaves are off the trees. I agree that patients can sometimes be loud. We ask them continually to remember that we are in a residential community. Prior owners allowed patients to use the lake in rowboats and on two large wooden floats. Immediately upon taking ownership, Cornerstone stopped that practice, and neither patients nor staff are allowed access to the lake. In my 15 years at Cornerstone of Rhinebeck, I have received very few complaints, and there has never been a patient that brought harm to the community. On the rare occasions we do receive complaints, we act swiftly to remedy the issue. In response to neighbor concerns over the past year and a half, Cornerstone has, for example, fixed omnidirectional lights to ensure there's no spillover onto neighboring properties. We've changed the time patients are allowed outside to minimize noise impacts in the evenings. We've changed the day of the month that the generator is automatically tested so as not to have a negative impact on the neighbors' weekend holidays. We've also reached out to the garbage collection company to see if garbage collection could be done more quietly. In addition, in connection with our pending planning board application, we have proposed a new tree line of evergreens between Cornerstone's property and the neighbor's house for additional noise mitigation. We have always and will continue to strive to be accommodating to neighbors' concerns. But we would also hope that the neighbors would be reasonable when it comes to this use that has been part of the fabric of the community for 40 years. We ask that the board uphold the determination on appeal and bring closure to these proceedings. Thank you.
Thank you, Michael. Okay, so members of the community, we have some here. Would you come up, please? And great.
My name's Edward Wilson. I'm a neighbor of Cornerstone's at 27 Dutch Lane. Edward Wilson. Hi. Yeah, thanks.
This way, take it.
Are you
Okay,
gonna-
so, we heard some legal points, which I think are all interesting. Most of us here are not lawyers. We're more about the common sense kind of experience of being members of this community. We've also heard, about the size and the intensity of the use. And I have to say that everything that we just heard from members of Cornerstone's management is not the experience of me and my neighbors. I've been a neighbor of Cornerstone's for, this is my 10th year as a neighbor of Cornerstone's. I've been a resident of the town of Clinton for about 20. Our experience is unfortunately not so good. We've also heard about the value of the mission that Cornerstone do, and none of us dispute that. It's an extremely valuable mission. I think we've said before, the good work that people do in this room with their patients is fantastic. We're all supportive of it. We don't think it should give a blank check to Cornerstone to increase the intensity of its use or the range of services or impact the local community in its quality of life. We also would say that Cornerstone is not a trusted member of our community, certainly not outside of those who work for them, who are here in support of their mission. Cornerstone has disregarded zoning laws for over 20 years. They've ignored notices of violation. They've claimed they were unaware of violations in spite of many written communications over the years. They've pointed to their Oasis licenses, which have changed many times, as permission to expand the capacity of their facility and of its treatment types. They've even claimed that the town has no jurisdiction over Cornerstone operations. So really, they've taken advantage of the ambiguity of the non-conforming use status to expand, and as such, have been very happy to live outside the law. Further, we feel that they are not good neighbors. Their business operations place a significant burden on the town and on its resources. We see it in visits by the sheriff, the comings and goings of ambulances, how many calls to the fire department are made. Even when there are no emergency services being used, and therefore town resources being used, we can see with our own eyes the routine traffic and the garbage on Mylan Hollow Road, which I can assure you is not coming from people who live here full time. Those of us who are close to their facility experience noise, we experience light pollution at night, and all of those environmental impacts, the traffic, the garbage, the use of local services, they increase with every patient they add. So that's what intensity increase means as an experience, as a neighbor experiences them. Now, up until tonight, we haven't really seen them make any meaningful effort or representation that they want to mitigate those impacts. So again, we don't seek to shut their operations down. We've said before the planning board that their work, if it's done well, is excellent work. We simply want them to respect the zoning laws and the special status they enjoyed when they were grandfathered in under those laws. We want them to be good neighbors. And I would also say that, you know, the short amount of time that their patients stay at the facility, you know, it's not that tricky to manage back to the capacity that they were grandfathered in at. The other thing that we'd say as neighbors and people who are subject to your code is, you know, the permit being sought is basically a retroactive one, which I've never heard of anyone being given a retroactive permit. And so it seems to us highly irregular that we should entertain this application or that the appeal would be ignored. Thank you.
Thank you very much. Appreciate it. Okay, other neighbors? Yeah. And just,
how's everybody? My name's Kevin Sheffield. Sheffield. Ffield. Kevin. Yes, I'm here on behalf of Cornerstone. I'm actually a recovering alcoholic. I came to Cornerstone in 2016, and the people at Cornerstone do a really good job with the patients. They helped me when I couldn't help myself, and as a result, it's now 2022, and I'm coming up on 6 years clean, thanks to Cornerstone. Thank you very much.
thank you. Hey, again, neighbors, I'd like to hear from a neighbor here.
Hi, my name is Kim Baker, and I live on Silver Lake. I don't hear anybody talking about the health of the lake, which has been declining over many years, and the neighbors are all working hard and spending money and time to try to clean the lake. I have concerns about 66 beds and the staff involved in that, which is, I imagine, I would hope, that brings us to about 120 people a day. So if you increase 30 people, you're talking about 99 people, plus perhaps the staff is 60 or 70 people. There's runoff every day. There are septic issues. I see the lake deteriorating, and I know that there's landing turtles. I know that Central Hudson has just put up these huge, along all of their power lines near the lake, they've put up underground fencing because they're afraid of impacting the turtles' paths with electricity lines. There's a lot of care being taken we were not allowed to build around the lake from April until November because of endangered species. Anybody who wants to expand their home and it's near the lake, it's not very easy because people are concerned about some of the endangered species. So my concern is, do we have a report from the DEC? Have they done a recent study on the impact of Cornerstone and the amount of people? Most of the residents around the lake are 1 or 2 people, 3 people, 4, not full-time for many of the houses, so the impact is fairly minimal. When you have, approximately 200 people a day, there's got to be an impact on the lake. And I would like to see the town ask for, an environmental study. Because if we're if we're asking Central Hudson to put up fences and all kinds of things and have a guy sit there all day in his car to make sure that nobody goes past those fences because the landing turtles can't get into that area, and if we're all asked to not do things on the lake certain times of the years, how can you even think that a septic system and a leach field with that many people increase is not going to affect the lake? And I just don't know. But I do see that the lake is becoming more and more filled with algae and lily pads and all kinds of things that could be coming from septic, it could be coming from runoff. So that's my concern that I'm asking you to think about as well. And
Great.
I didn't hear it mentioned tonight.
Yeah, I appreciate your concerns for our environment. We're concerned about that as well. Though again, this board unfortunately is not assigned to address those, but rather the specific content of the administrator's letter. But thank you for bringing that up. Yes, a neighbor? Your neighbor, okay, come on.
I don't really want to get too close to that thing, but my guess is you can hear me.
Yes, and what's your name?
Randy Sackheim. I live on Deer Hill Road.
How do you spell your last name?
Sackheim. And I've lived there full-time now for 20 years. But I've been going up before that in summers. It was my ex-husband's family's home for maybe 6 years before that. And I watched Cornerstone change. Just one thing, there have been several times where men have run by my house. I live at the dead end of the road. I call Cornerstone. I go, I think you might be missing somebody. And they won't say whether they are or not. That's probably a legal issue. They tell me they're going to come by and check it out. They never have. I call a neighbor just to let them know that there's some stranger running into the woods. It's uncomfortable. May I also say, and this isn't easy for me, my ex-husband was addicted to crack, and his first stop was at Cornerstone. It is a for-profit facility. It's not a not-for-profit facility. And having seen what he's went through for years, I can tell you that there's a big difference. I have nothing but respect for what the staff does and how difficult it is to work with people who are addicted to drugs and alcohol. It is a horrible and hard situation. We do not have an issue with that. We have an issue mostly with how the place is run, how they've ignored our requests for years, the trash, the people that they don't seem to be able to keep track of all the time. When my husband was there, at the time he was my husband, I went over there to talk to them to say, there's no barrier. He can walk to my house, to our house. It was a horrible situation. He stole from neighbors to feed his habit. He stole from me. I didn't know what was going on. I had no idea what his problem was at the time. A friend took him, found out, checked him into Cornerstone. He started using a minute and a half later. He was there for, 2 weeks. He went through several of these facilities. He is thankfully clean now and has been for quite some time. But they were always not-for-profit facilities and churches and synagogues that helped him. And they were part of communities where they lived. They volunteered, they made themselves available to the larger community. Cornerstone has never done that. And when I went to them and said, in the dark, blindfolded, he can make it over to our house. And they just said, because there's no barrier whatsoever, they said, we count everyone a couple of times a day, maybe once an hour. And that was it. I no longer feel like I can not lock my house in the night. They have complete free reign, and these are troubled people. I'm not blaming them at all. But they're not good neighbors. And I feel very deeply for what they do. That's all.
Thank you. Other neighbor? Yes, go ahead.
Hi, my name is Art DePasqua. I live on Deer Hill Road, and I'll keep this very brief. My concern here is a little bit different than other people because I'm on the planning board. And what I see here is related to Cornerstone and other applicants that we see come across. The way the latest ZEO letter is phrased, to me, opens it up for anybody to disregard zoning laws, come in and say, oh, I'm sorry I did that. Let's get a permit now. And it's not just Cornerstone, it's other. I think we'll set a terrible precedent without some sort of procedure that this current applicant has to go through, whether it's going back to 66 beds and reapplying to go to 99, I don't know exactly, but there has to be some sort of a control on what goes on, because this won't be the only one we see, believe me. So that's all I have to say on this. Thank you.
Yes, thank you, Art. Okay, others? Let's see. Yeah, go ahead.
My name is Edward Jenkins, and I'm an employee for Cornerstone Medical Arts. I'm the senior counselor of the rehab unit.
Your name is Ed?
Edward Jenkins.
Can you spell your last name?
Jenkins.
Thank you.
I'm sitting here and I'm listening to all the concerns about Cornerstone and the wanting to decrease the bed there in Rhinebeck. And I'm listening to people, and with all due respect, I'm quite sure that none of you who are wanting them to decrease beds have received phone calls from mothers telling you that their son has OD'd, or they come home from vacation and found,
just if you can address the board.
Found that their son dead with a spike in their arm. You see, what we do at Cornerstone, we don't just treat and detox an individual. Holistically, we're treated. I introduced myself as Edward Jenkins and the senior counselor of Cornerstone Medical Arts Rehab Unit, but I'm also a retired alcoholic and dope fiend. I could only imagine that my 10 children, 44 grandchildren, and 14 great-grandchildren, what would they have done if I would not have been around? If it was not for Cornerstone, I would have died. I would have died. We're making a senseless argument about how many beds. We don't have enough beds. Right now we're in the plague, a pandemic that they call COVID. Chemical dependency have been killing people for decades. We need as many beds as we possibly can. I live in the world, in my mind, without borders. It's okay that Cornerstone treat people, but not in my neighborhood. This is a problem. This is a problem. It's okay. Cornerstone is doing a great job, as long as they don't do it in my neighborhood. That's a problem. We have to address this chemical dependency issue at every level, no matter how many people we have to service. If they had to pack that building to the point to save just one life, I think it should be acceptable to all communities. Thank you for letting me speak.
Thank you, Edward. Okay, and a neighbor. I'd like to hear, we have a neighbor that would come up and share with us. All right. I'm attempting to balance this, so we just don't get all one side or the other. So I appreciate you all helping out with this. Yeah, go ahead.
Yes, well, my name is Christian Fekete.
All right, so you're going to have to spell that for
F-E-K-E-T-E.
E-K-E-T-E?
Correct, yes.
And your first name?
Christian.
Christian, okay.
Yeah.
Okay, go ahead.
Yeah, so, I'm more concerned about the non-conforming use discussion that we're having. And I want to talk about really what that means. I'm not going to go into the detail, but really, if it's non-conforming use, and we're at the same time talking about the increase in intensity of the use, I don't really understand what the argument is that whether or not it's legal to keep it or to extend it. To me, non-conforming use is non-conforming use. So how can you even consider expanding on this without having the use conform to the zoning? Unless we redo the zoning, it's the spirit of the law is that we're limiting that use. So if it's anyway, that's what I wanted to address. The other thing that I wanted to talk about is I hear neighbors talk about people walking in the woods, and I see constantly on the road people that are sitting in their cars that obviously, I talk to them and I say, do you need something? Do you have a problem with your car? And I get responses that are in general dismissive or not aggressive, but it looks to me like there is a lack of framing of the activity or the people in this facility that is impacting the neighborhood in a negative way. And I think that it would be useful if that increase in non-conforming use was granted to attach to it some requirements so that Cornerstone could or would be obliged to provide a more a clearer limits to their properties. I don't know what that means, but I think it would behoove the town of Clinton to define, like we define architectural, specifications for design, so that some kind of design to prevent this spillover of uncomfortable situation. That's what I hear from the neighbors, and I think that if we all agree that the Cornerstone use is a good use, we have to find a way to prevent that type of interaction that is a negative interaction. The way that they run their business is their business. I don't want to get involved with it. What I don't want to get involved with also is to have my friends, my neighbors being afraid for their children because they don't know if someone is going to come too close to their children, and they're concerned for their family. So that's what I'm concerned, and I'm not happy to have these people hang around on the road and just like, I don't know what's going on. What are you doing? It's just like, it's kind of weird. So I just want to get rid of this weirdness. That's all.
All right, thank you. Okay, any Cornerstone? Yes, go ahead.
Good evening. Does that sound okay?
You're good. You're
Okay,
good.
I'm Jennifer Schofield, Schofield, and I'm freezing. Good evening. My name is Jennifer Schofield. I started working at Cornerstone in Rhinebeck in 2009 as the clinical director. Late last year, I became the vice president of clinical services. I'm a licensed clinical social worker. I have worked in the field of addiction since 1997, coming up on 25 years doing this work. First, I want to thank our neighbors for your support. I'm going to turn my face this way, for your support of the work that we do at Cornerstone and the compassion that many of you have shown towards those who are sick and suffering. I hear that. To our neighbors who respect and honor what we do, but whose main concern is that Cornerstone simply must follow the rules like everyone else, I say that I agree 100%. This is exactly what we are trying to do through our pending application to the Planning Board. I want to talk about community for a few minutes. I was born and raised on Long Island. Then I lived in the city for many, many years. I eventually moved to the Hudson Valley in '96. I met my husband while we both worked at another addiction treatment facility in Beacon in the late '90s, and he has worked for 30 years in this field as well. We moved from Poughkeepsie to Rhinebeck in 2013 with our daughter, who will soon enter her junior year at Rhinebeck High School. Throughout previous planning board proceedings, I heard a lot here in this room about what it means to be a good neighbor in this area. I have lived and I have worked in many places, and I have found that being a good neighbor, quote, being a good neighbor, is different depending on where you live. In the city, I never learned my neighbors' names, even after living for 10 years in the same building. In stark contrast, here in the Hudson Valley, I often think of a night years ago when a big tree came down in a storm and many neighbors on the block, including my husband, went outside immediately with a chainsaw, and everyone brought their chainsaws to clear the road. Such a different neighborhood experience, one that always reminds me of the small town where I was raised. I give you this history because I want to express that living and working in Rhinebeck has made me feel like part of a community for the first time since leaving Long Island as a teenager. At Cornerstone of Rhinebeck, we have always tried to be good neighbors. We talk about it. We strive to be as quiet and unobtrusive as possible. We have no bright lights outside. We do not allow noise at night. We transport our patients to and from the facility in unmarked SUVs, regular vehicles. We do not have big, ugly barbed wire fences or loud alarms. The buildings and grounds are kept very tidy. I think they blend beautifully into the landscape and the lakefront. It's gorgeous. I have learned, also here in this room, that perhaps this is not what some of you think of when you think of a good neighbor. I would very much like to fix this. I'm a problem solver, and I hope that together we will be able to improve community relations. Moving forward, I would be very eager to meet with anyone in this town, anyone in this room, to find out more about your worries and to work together to find solutions. I also heard some things here that upset me deeply. There were accusations that we at Cornerstone mistreat our patients, that we are providing subpar addiction treatment, and that we are only a for-profit money-making industry. I can tell you, after working at Cornerstone for such a long time, that the treatment we provide is of the highest caliber. County, state, and federal regulations guide our every policy and procedure. We are strict with ourselves, and we as a group hold ourselves to extremely high standards. We never give up on our patients, and we are here for them whenever they need us. We use evidence-based treatment models. We all work diligently to arrange aftercare plans for everyone who leaves our program. Our patients report consistently that we saved their lives. They give us the highest compliment when they refer friends or family to us for help. Our patients call us on their sober anniversaries. Our patients come back to visit. I have been a part of the treatment of thousands of patients at Cornerstone, and I am so very proud to work there. I can also tell you that nobody enters the field of addiction treatment to get rich. Human service jobs are not high paying in dollars and cents. We get paid with the satisfaction of helping people rebuild their lives. Each patient we help is like a pebble in a pond. There's a ripple effect in their families and in their communities. We create and spread mental, emotional, physical, and spiritual health. We save lives. I ask that when this board considers this appeal, it does so with a thought that is constantly on my mind, a thought that literally makes it difficult for me to sleep at night. If the number of our beds is reduced, then that means that on any given day or any given night, we will have fewer people in treatment getting help. How can we, as a community of neighbors, possibly justify helping fewer people in need when we have the resources and the desire to help more? Thank you for your time.
Thank you. Thank you for your comments. And just as a general comment as well, we are concerned. We're in this neighborhood together. So I appreciate, Jennifer, you mentioning that if anyone has concerns that they could reach out to you to discuss those. Again, let's take advantage of that opportunity as much as possible, regardless of the situation. Because I hear, again, right now we're speaking specifically of 66 to 99 beds and the decision that was made by the zoning administrator, but none of this decision is whether or not this institution will be here. So if there are concerns that we have as a community, please feel free to reach out so we can discuss them, again, so we can work together. A neighbor. We have a neighbor that would like to share.
Hi, Kat Maxianova.
All right, can you
you hear me?
say that again and then spell your name?
Maxianova, Maxianova.
And your first name, I'm sorry?
Katarina, Katarina.
Okay, yep. Okay.
So I'm going to read my remarks and I'm going to add something at the end. So Cornerstone Management says we don't fully understand what they do and we don't really know what we're talking about in some way. But we have been here for 12 years, within 200 feet, my husband, my children, and I, and they have never reached out to anyone to tell us what they do. Their operations seem to be cloaked in secrecy. We have tried reaching out, and I'll talk about that, what we learned, but for most part, we just rely on what we see and read. We see their patients' faces and hear conversations daily. Those patients whose privacy they allegedly are so concerned about. Often they play sports, which is great, they're having fun, but frequently there seem to be fights and they seem to be in distress. We hear and see ambulances, sheriff cars, fire trucks, often multiple times a week, at all times of the day. We see needles and pill bottles, often with patients' names, still on them, laying on Mile and Hollow Road, mere steps away from our children's school bus stop. We run into patients who have left or were kicked out, sitting on the side of Mile and Hollow Road, aimless and lost. We get alerts about registered child sex offenders staying at the facility, including child rapists. We have reached out to the management multiple times. The only meaningful conversation we had with them was initiated by us in December 2020. During that conversation, we learned that 60% of patients are from New York City. The rest are upstate New York. We also learned they see themselves as a short-term program. Their detox program is 5 days. Their rehabilitation program is typically 28 days. But how long it ends up being depends on what the patient wants and needs, but also what the insurance will pay. We learned they work extensively with parole and probation offices, as they admitted. In their own words, they work mostly through the drug courts and the alternative to incarceration programs, like Midtown Community Court and Brooklyn Treatment Court. So it's for people who have alternative to incarceration, and that's a quote from a conversation status. We ask about registered child sex offenders, not to discriminate, but to understand the procedures and to get peace of mind. We are literally 30-second walk from the facility with absolutely no barriers, no protection. The answer didn't help. They said, we don't know if someone is a known sex offender. When we explained that they are all in a state database and that each relocation gets recorded when an offender moves, they said, well, they don't live with us. They are with us for a very short time. Now, they need to use this database themselves to check their employee offender status, so they know it exists. They know how to use it. They just choose not to do that. And most importantly, for zoning purposes, they insisted that they are not an alternate care facility, but a hospital. They said that to me very clearly. They said, we're not an alternate care facility, Kat. And again, they said, we know we're a hospital, and we have always been a hospital. And they said that's what their attorney at the time, Werner Plonsky, told them. Now, finally, I have some comments about issues with trust. While we were having these conversations, they told us they had no immediate plans to expand. So it was disappointing to learn that while they were telling us all these things, they were in fact working with the CEO in the background to try to expand the facility even more. It was at this point that we lost trust and decided not to engage with Cornerstone directly. Now, if there's room to engage and rebuild a relationship, that's great. But frankly, we have doubts about their current intentions as well. So they're really trying to rush this through and hoping for a resolution today or next week. Well, we know there's a potential buyer and change of ownership pending for Cornerstone. It's on file with Oasis. It's public information. It's been approved by Oasis. 90% of ownership potential will be transferred to another individual as soon as this gets cleared. So this is not, an attempt to go and continue to work in the community. This is an attempt to clear something to get a sale through. Just like last time in 1998, it was an attempt. The reason why Rhinebeck Lodge even got the status of alternate care facility was to clear the sale to Cornerstone. So I feel like we're reliving the history here. Back then, it was a sale to Cornerstone. Now it's a sale to, I'm not going to say the name of the individual, but again, happy to share. It's public knowledge. It's on the Oasis website. That's all I have to say.
Thank you, Kat. Someone from Cornerstone. Is there anyone here to share from Cornerstone? Yes. Sure. I like that, brief.
I'll have you know that what I said before was very brief for an attorney. This is where, okay. So I just wanted to say for the record that a lot of things have been said tonight that we vehemently disagree with, we think are false, are irrelevant to this process, so we are not going to go statement by statement to refute everything. But I just didn't want to let it stand that we accept everything that's been said here. And I think this board understands what its jurisdiction is here, and that much of what's been raised here is either completely irrelevant to zoning, irrelevant to this proceeding, and maybe raised also in the planning board when we talk about impacts and things like that. So I just wanted to take that opportunity to just put on the record that we don't agree with everything that's been said. It's not all true, but it's not worth going through every step by step. The last thing I want to say, though, is it's been mentioned by a couple of people, including the planning board chairman, that it's going to set bad precedent to allow retroactive approvals. And again, it's also not something before this board, that's a planning board issue. But it happens all the time. We could talk about the intent of Cornerstone. They didn't intend to break the law. They didn't intend to violate zoning. We could discuss why we feel legally they don't need to be going to the planning board, but we're doing it with reservation of all our rights to be a good citizen and neighbor, and because we were told to, whether we disagree or not. Retroactive approvals happen all the time. Think about the guy who built the deck, went into a setback, and comes before your board to try and legalize the deck. Nobody asked them to take the deck down first, then get approval, then put it back up. So I just don't want it out there that what we're doing is untoward in any way or unique. So we're here. I'm glad that people heard that we're willing to talk to the community about these issues, but that's all I have to say. Thank you.
Thank you. Okay, further comments from neighbors? All right, we're going neighbor now, so, all right. Kyle, do you want to? Okay, any other neighbors to share? Okay, I'm sorry. Yeah, come on up.
Hi, I'm Tim Dumbleton.
All right, Tim, can you help us with your last name, if you can spell that for us?
D-U-M-B-L-E-T-O-N.
Okay.
I'm a resident. I'm also a licensed architect in New York State. I've also been involved in at least a dozen rezonings. I've rezoned and built 2 million square feet in New York City. I've done rezonings in Los Angeles, Miami, some of the hardest places to do rezonings. I'm also a developer, so I'm not like a big NIMBY. I'm not a huge fan of a lot of zoning, but I have to tell you, when I look at the zoning issues in front of me here, it's super clear that these guys are trying to increase their nonconformance. The analysis that their lawyer gave about the gas station is completely inapplicable, right? It's not saying that there's 2 gas pumps and more people are coming to those gas pumps. They've doubled the number of gas pumps, and you damn well know that that would come to front of the board if that was actually what the gas station wanted to do. So I just wanted to give you my opinion as an architect and someone who's done a lot of zoning work. This would have been completely an easy decision in most jurisdictions. That's all.
Thank you for sharing. All right. Kyle, did you want to some time?
I just wanted to touch on a couple of things because I'm not sure. I think there might have been a little confusion when I've heard some of the following comments. It doesn't matter what Rhinebeck Lodge was doing in 1994. It matters what Rhinebeck Lodge was doing when they were grandfathered. So simply to get up here and say, well, Rhinebeck Lodge was considered a primary alcohol care facility. They got that certification in '94, which they did. That right then and there, that was as soon as if they ever engaged in those services, we don't know whether they did, but as soon as they actually engaged in the services of providing detox, that would have been an illegal expansion of the use. So I think I don't know why there's that emphasis on what happened in the mid-'90s, because it matters what it was doing before the zoning went into effect. And it couldn't be clearer when you look at the definitions of detox. I mean, even in the regulations, detoxification under Title 14, Article 816.4, is a medical withdrawal and stabilization regime under the supervision of a physician to systematically reduce the amount of an addictive substance in a patient's body. And that does not exist in the definition of ACF or the rehabilitation services facility. There's no way you can glean that from what's said in that. And the reason also that you know that is because elsewhere in the code, medical is defined. They define medical in the town code. And that's defined, let's see, page 8. This is why I should have brought my glasses. I mean, pardon me. Yeah, no, that's all right. I'll figure it out eventually. Oh, thanks. You don't have COVID, do you? Okay. Thank you. Medical in the code, sorry for the delay, is defined under town code as a building designed or used for the diagnosis and treatment of human or animal patients, which does not include overnight facilities. That's town code 250-105. A hospital is defined an establishment for temporary occupation, including overnight admission of the sick or injured for the purposes of medical diagnosis and treatment. So clearly the code envisions what those types of activities are, and an alternative care facility isn't one of them. That's the issue. And the also thing that it's missing from, I don't know if it was in that handout that was provided, but curiously enough, when you look at intensity, and by the way, there's no question that town boards town code can regulate intensity. There's a case right on point from the second department, which is the department we're in, which says that the law in New York is clear. Courts, in keeping with the sound public policy of externally extinguishing all non-conforming uses of property, will enforce municipal ordinances which restrict an owner's ability to expand or intensify a prior non-conforming use. Your code does that. The cases cited by Cornerstone don't deal with a situation where a town code prohibits the increase in intensity. It just doesn't. Thanks.
Thank you. How's everybody? We're just going to pause for a brief second here. How's everybody doing? You okay for a little bit longer?
You want a break?
I'm just asking. We'll hear a couple more. All right, so we're going to take a 5-minute little recess here to use the bathroom, get a drink. So we'll say at 9:37. So feel free to stretch your legs, walk around, and meet us back here.
said that they should also, that does exactly what we do in a non-acute So the question is, should I get up and say it? I got it.
You and I collided in both.
Tell me.
Well, mine's bigger than yours.
She gets great hugs, by the way. Great hugs. She gets great hugs. You guys are so cute. I love it. I like you outside of work. He's so tough at work. He's and I work so hard. I'm like, Jeff, when I she's telling on you. I did that. Yes, I did the same thing.
Yes, thank you. But the only problem is, I should have taken the
He's supporting.
He's working on his next summer's job, and he's 18. He's like, I gotta get him good with Michael.
You want me to stay here 2 hours of the night?
Yes.
Just asking. I'm glad I had coffee before I got here. Any food there? Like everything.
They got like
Snacks are good. You have Wawa up here? I got so. You see outside I got Wawa? Can't. You can tell I'm a Jersey girl. Wawa. We love.
Ladies and gentlemen, I'd ask that you take your seats again, and we'll get back to it by sharing a few final comments.
All right, go ahead. Judge, go ahead. Just make sure that Brandon is back.
Yeah. Brandon, are you ready for us again? Okay, great. Just as a reminder, again, we are providing this opportunity for the public to speak and to share their experiences. You okay back there? So we want to provide this opportunity for you. So at the same time, it is getting late. Would like to hear, again, if there are any further comments that we have from the neighbors, and then any, what I'll say, more final comments from Cornerstone, so that we can, wrap up this evening, and then we'll see if there's any questions specifically that we have from the board members, and we'll take it to that point. So I want to start with neighbors. I think there was maybe one that had raised her hand before. Was that? Yes, sure. Again, if you would focus on new information and be as brief as possible.
Very code specific.
Okay.
But before I do that, I wanted to say, just respond to the comments about inaccuracies and misinformation. Anything I said in my remarks that referenced the conversation with Cornerstone Management, we did it as a Zoom call, which is recorded, which is available to view. So if there's any doubt around anything that has been said, happy to share it with the board.
Okay. Thank you.
So the other thing is, a couple of things that kind of are going through my mind. And again, this goes back to the difference between rehabilitation as defined on ACF and detox. And the question I have is, or the thinking I'm going through is, we know detox is a short-term process, right? It's maybe 5 days, according to the management here, but maybe, let's say 4 to 7. Either way, a patient who comes in for detox stays a week, 1 week, right? Now, ACF is defined in our code as residential use. So it sits under residential uses, principal residential use in the code, in the zoning use schedule. Residential is defined as, let me just read it to you. Residential is defined as used as or for a dwelling, as herein defined. Dwelling is defined as a house or other building designed or used primarily for human habitation. The word dwelling shall not include tourist homes, mobile homes, camping vehicles, motels, hotels, or other structures designed for transient or temporary residence. Now, transient is defined, let's see, transient. Transient is defined, transient, used herein to mean any occupancy of duration less than or equal to 14 days in a calendar year. Temporary is defined as, for the purposes of this chapter, temporary shall be defined as a period of no more than 30 calendar days. See related terms, occupancy, seasonal, or transient. So in my thinking, detox is a transient use. You can now come in and stay for detox for 7 days and be considered an ACF, which is a residential use, which should be over 30 days. And frankly, ACF alone is skirting the line of 28 days. But again, short-term stays, short intensive medical detox is not a residential use.
Okay.
That's it.
Thank you.
Can I ask a question?
Yeah.
Sorry. Could you expand on your comment about the conversation being a Zoom call with Cornerstone representatives?
Yeah.
Is it a local representative of Cornerstone?
It was Dave Bachner and Michael Burnell.
And that was a recorded conversation? Earlier in your comments, you mentioned that during perhaps this conversation, those representatives defined Cornerstone as a hospital? Okay, and not an ACA?
Yes.
Thank you.
They were quite clear about it, yeah.
Okay. As far as again, new information. I'm just going to hear for a few more minutes from the public at this time. Any other comments from neighbors to share? Yes.
Hi, my name is Dieter Schollenberger. I'm a neighbor on Deer Hill Road. Arlene, you know my difficult name. SCHOELLNBERGER. So, sorry, it's a mouthful. So I'm here now on Silver Lake for like 5 years. I think we heard a lot of it. I don't want to repeat anything.
Thank you.
I think Cornerstone staff level, all your work, I think it's all appreciated and well done. I don't know if you guys all know what management really is doing. Kat mentioned it at the end of her thing about the sale, and I think that's what you guys should look into as well. It's out there. If there's anything that goes through right now and gets approved, tomorrow Cornerstone is sold. We are dealing with a new entity, and then what? So whatever we agree here now, whatever is coming up, tomorrow it could be different because there's a new owner, and I don't know if everybody really knows that. So that's it.
Great, thank you. Okay, any other comments? You have a question? All right. Sure.
The question is,
the name
this
again, please, for the record.
Christian.
Christian Fekete. Yeah. This non-conforming use, if it's, I guess, call it granted or it's approved to be continued, does that mean that if they sell their property, that nonconformity continues with the buyer of the property?
The whatever the property has, the property maintains.
Okay.
So if there's a non-conforming pre-existing use on the property and it changes hands, that would continue with the.
Okay, so
new
it means
ownership.
that really that the zoning of that property has changed with that action, right?
I'm not sure what you're asking.
Well, if it becomes a conforming use at that point, right? No, it's still a non-conforming use?
Yeah, right now it's already established that this is a pre-existing non-conforming use.
Right, but if their expansion is granted on a non-conforming use property, does that non-conforming use become conforming?
No.
No,
It's-
okay.
It's always non-conforming, yeah. Okay. Further questions from the neighbors or comments? All right, Cornerstone. Yes. We'll wrap up final comments for the evening.
I'll be very quick, and my client's just going to talk very quick after me. Promise it's going to
Okay.
be quick. First of all, just obviously the sale of whatever is going on there is completely irrelevant, and neighbors don't understand the details of that. We're not going to go into that. The other issue is that we also know that sometimes residential uses don't always include homes. I represent a lot of community residences, Padavan. Some are, long-term, some are for eating disorders where they're there for short-term. So I think this board understands that residential doesn't always mean houses. Also, I don't know what my client said on the Zoom. I don't know what's on that video. I will point out my clients aren't attorneys. They aren't zoning lawyers. If they said hospital, which I don't know that they did, but if they did, that doesn't mean it's a legal admission based upon the zoning code and legal interpretations. And lastly, my client's going to speak about the fact that what the public and the general lay people know about detox isn't what the clinicians understand. They know better than I do what detox is, so my client just wants us to very quickly explain why this being detox is not a hospital medical use.
Great, thank you.
David Bachner, Bochner. OASIS mandates and sets the criteria for admission to any program in the state. And for detox, there's 3 levels of detox. I think Mr. Barnett was quoting the 816.4 regulations, which were applicable, I believe, to all levels of detox. So there's 3. The first one is called medically managed detox. That's done in an acute care hospital. It's called an Article 28 hospital, similar to Northern Dutchess. So if someone required a medically managed detox, they would go to any number of local general hospitals up to and including Northern Dutchess. The second level of detox is called medically supervised withdrawal services. That is what Cornerstone provides. There's two levels of withdrawal services. One is inpatient, which is Cornerstone, and there's one that's outpatient, which of course is not us. We often evaluate a patient who comes in seeking treatment at our program, and they don't meet the criteria for our program. They actually need to be in a hospital. They need a higher level of care. We do an evaluation with them, and we transport them to the local hospital where they can get the services they require. We're not a hospital. We are not an acute care facility. We're a subacute facility, and Oasis wouldn't license us to perform this medically supervised withdrawal service if it had to be done in a, quote, hospital. So I just want to make that clear. I'm not sure if it's a little bit nuanced, and we live this and deal with it every single day, so to us it's what we do. But I think if someone doesn't know they are the 816 regulations as part of the Oasis Code, it's an important distinction that there are levels of detox, again, one of which requires an acute care hospitalization. Some detox is done on an outpatient basis, where someone goes in for the day and then goes back home. So detox has all different kinds of levels, not just in a hospital. Thank you.
Thank you. At this time, I'd like to hear comments from the board or any questions that we may have. Again, this is very much a gathering information evening. Russ, do you have?
Well, I have some statements. I don't know if they're comments, but in the handout that we got from the lawyer for
For a lawyer for Cornerstone, it says zoning code 250-81 non-conforming uses. And it says any lawful non-conforming use of building or land in existence on the effective date of this chapter, and then have ... Those ... are very important. It should say, except as disallowed by 250-80. It just goes ahead and says may be continued. So you left out a very important thing, because 250-80, I think, disallows some things. So that's a comment I've got on what we received from Jody tonight. And I don't know if you want to go on other things within the paperwork we got, but I see one place in here it said that Cornerstone wasn't aware of a violation until they received a letter, I think, from Mr. Fenton. But in the Oasis statement, it says that you must also comply with local authorities. So every Oasis time you got that means that you were supposed to comply with the town zoning law. So you put on notice as soon as you got that from Oasis. So it's like you weren't really unaware. I see that both Mr. Fenton and Mr. Fennell both said that increase in population would be a violation. I'm looking at 2005 on the bottom, and it is my considered opinion, Town of Clinton zoning law does not permit an increase in the number of clients in Cornerstone. That was from Mr. Fennell, 2005, and then there was subsequent stuff from Mr. Fenton, I believe, that basically said the same thing. Just some comments I've seen going across it.
Thank you for sharing those, Russ. Again, questions here, comments? John?
In a moment.
Yeah. Norma? Okay.
Everything I have notes on. We're addressed in the paperwork.
Great. Ron?
I think I might like to address the staffing.
Yeah. What's that?
Digest.
Yeah. Sure.
Sorry?
Digest.
Yeah, no.
Okay. I guess my question would be for Mr. Purnell. Going from 66 beds to 90-plus beds, 50-ish% increase in residents. You may have touched on it. If you did and I missed it, I apologize. How was that, how does the staffing relate to that increase?
The staffing that we have is averages 35 a day, spread over 24 hours.
Oh, can you ask him to go in the microphone?
Oh,
please?
I'm sorry. I guess I'm going to have you come up.
Now, the staff that we have averages 35 staff a day, not all of whom are on the property every day or during the day. Some people do work from home. The 35 staff are also spread over 3 shifts.
So was that 35 consistent prior to the increase? Or was it 17 prior?
No, we did not have to double staff to make that accommodation to 99. Absolutely not.
Okay.
I mean, there's a certain amount of, you need a certain amount of staff in each department.
So it does not increase in direct proportion to residents?
Not at all. Not
Okay.
at all.
All right. The reason why I ask is that, I just kind of struggled with your, I guess, comment that, the increase in residents was imperceptible to neighbors. And I just, just in common sense with, cars and as you stated, or one of your associates stated, garbage pickup, it would make sense to me that it would in fact have to noticeably increase.
Increase, of
Staffing
course.
would be a piece of that.
Increase, of course. I'm not sure about the amount of increase. I mean, there are dumpsters, you can easily get a bigger dumpster, if you have more trash, more garbage. But I can't argue with your logic, put it that way, that with more people, there's going to be more garbage. I mean, I can't argue that.
Okay, I appreciate your time. Thank you.
John? Yeah, I'd like to just get some clarification. Maybe Mr. Barnett would answer this, but Section 250-81 states that where no building is involved, a non-conforming use of the land may not be extended to occupy a greater area of land. And then the part that I'm interested in, or to include more intensive use of the same area of land. Emphasis added. Can you break that down a little bit for us to maybe convince us that although there's more people on the property, more beds, more meals being served, somehow there is not a more intensive use going on here?
Well, I might, there might have been 2 questions, if I may. And if
However you want to answer
Okay,
it.
thanks. So the first is the section you've cited, which deals with, I think, primarily when there is an increase in intensity on unoccupied or vacant property or vacant land, which is what's prohibited, right? In terms of this situation here, the prohibition in your town code is found in the paragraph right above that in 250-80, which says that, and I'll read it for you. It says basically that the here it is, which basically says 250-80B, which says the intent of the article is to limit by not increasing non-conforming uses and to eliminate such uses as speedily as possible, but at the same time to alleviate economic hardship to an existing non-conforming use by allowing it to continue at the existing level of intensity. So that's I think, the operative code section here. The other paragraph regarding prohibition against increasing intensity, I think, only deals with when you're taking a non-conforming use and moving it out onto other parts of the parcel that wasn't being used before, which is also prohibited. Did that answer your question?
No.
Okay. I can tell from the way you were looking at it.
What I'm looking for is a way to judge whether the changes that have taken place from 66 beds to 98 beds, or any increase along those lines,
Yeah.
how do you justify or evaluate whether the use of the same area of land on which, I mean, they haven't added more land.
Right.
So they've got the same area of land. How do we judge that that use is more intensive? You would be, I would assume you would conclude that it's more intensive.
Correct.
Not similarly intensive. So how are you judging that?
Well, just by two things. What's more intense is obviously the number of people that are being served. It's a 50% increase in the number of population that's being served. That's not even a little bit more intense. That's significantly more intense.
Okay.
And I don't even think there's any disagreement between us and Cornerstone that an increase in the population by 50% is a more intense use. The disagreement, I believe, is the fact that they're saying, well, because all the cases they cite say that a greater intense use is permitted. It's not considered an enlargement of the use. That's the argument. So notice that the argument really isn't over whether the use is more intense. I mean, I don't know how you can say it isn't with a 50% increase in the population. The argument is whether or not the code permits it. And I think that's really what needs to be judged, as opposed to, whether that is more intense by definition.
Thank you.
I mean, as is, by the way, I think you could also make the same argument regarding the addition of services obviously creates more of an intense use, but it's obviously much more clear and unambiguous as it pertains to the 50% increase in population.
Before you sit down, you said in our zoning code, we had a stipulation that allowed us to use, I think something to do with the increase in population or something. And if it wasn't there, it would be a problem, but in our zoning code, we had a section you were referring to.
Right, that's the 250-80B section.
Okay, we're at its existing level of intensity.
Exactly.
And some don't have that in it, but ours does.
Some towns don't. No, I've done a lot of these non-conforming cases, and there are towns that simply prohibit the enlargement or extension of a non-conforming use. And I think if that was the case, then a legitimate argument could be made, well, an increase in intensity isn't necessarily a violation of that. But here, your code does. And there's a case from this department right on point that gives this town the authority by code to regulate intensity. So, I mean, I cite that case in my papers as well. So it's not like the town can't regulate intensity from their code. They can, and you do. And so I think it has to be followed. Yeah.
Thank you.
You're welcome.
Cornerstone, like to add to that, or?
Because I disagree that, we don't agree that it's an intensification of the use. I guess I say, first of all, it's not our burden to prove here.
I get
So
it.
I ask, what does intensify mean? Adding more people increases the number. That doesn't mean it intensifies the use. And I also want to point out that the section of the code that keeps being referred to as a prohibition is a legislative intent and policy statement. It says it's the intent of this code. It doesn't say, it's not really what he's saying it is. That legislative intent is then put into effect with the section that says thou shalt not enlarge your non-conforming use. So I disagree with the import of that paragraph. I'm sorry, I don't have the site available to me. I think it's important, but not for the reason he's saying. And I disagree that it is an obvious intensification, whatever that word may be, without empirical evidence or an understanding of what that means. At best, it's ambiguous, and in that case, the case law says it has to be interpreted in the landowner's favor. So if there's any ambiguity, it's in our favor. And I don't know that you could demonstrate that 30 people create an intensification of the use. Because remember, it's the use, not just the business. There's a big difference there. And that's what the cases say. Thank you.
Okay, thank you.
Sure.
I just want, I will point out, unfortunately, I missed, maybe I.
The mic allows people that are not here to hear what you're saying.
So it doesn't occur to me. I'm pretty sure it's in there, and this is the reason. I don't mean to I didn't mean to misquote Jody. Obviously there's a disagreement. Raplansky, who was the other lawyer for Cornerstone, put in writing that this was a more intense use. So that's all. I mean, so apparently I agree with Raplansky, the other attorney for Cornerstone, about the intense use. But obviously, I guess Jody says it's not. Although I don't know how reasonably you can come to that conclusion, but that's for you guys to figure out. Thanks.
Sure. Norma?
I have one question.
Do you want to turn your, maybe?
It's in the paperwork.
Great, thank you.
There's a building mentioned that was put over an old pool.
Storage pool.
There's a building on the property that was put over an old pool. What is the current use of that building?
I think originally the pool was just an open air pool, and at some point, Rhinebeck Lodge covered the pool and made it an indoor pool, an inside pool. It hasn't been a pool since Cornerstone has been there. So now it's just an area where we store things.
Store things? No.
Yeah, I mean, it's still connected to the building. There's still doorways in between. But yeah, I mean, there's no other use we can make of it at this point. Okay, I mean, the pool is, the hole that used to be a pool is still right there.
No, I just didn't know what the building.
Yeah, all they did, they didn't build another building. They just covered it. Okay, so it's still a flat slab, as you would with when you build an in-ground swimming pool. So.
Strictly storage.
Yeah.
I thought.
Oh, there's no. There's no patient bedrooms. There's no patients allowed there. Dirty linen. I mean, that's all we can use it for. Okay.
There is reference to this being approximately a 3,000 square foot building, though, correct? Storage building, I think you call it.
3,000. Yeah, I could. Yeah.
Single story or two story?
It's open air, 2-story.
So it's.
I think your paperwork refers to it as a pole barn.
It's open though, correct? There's not, when you say 2-story, there's not like a floor.
No.
above it, right? So
I think
two-story
the
just means height.
paperwork refers to it as a pole barn.
Okay, yeah.
So, okay.
Okay, thank you.
All right, any other comments or discussion from the board at this time? Okay, so at this time, we're just going to table this. We're not going to close the public hearing, as that allows us and others time to discuss this further. Just comments from the board, if they would like to close the public hearing, if they see this differently.
That's a good question. I think we've got what we need to make a decision. It's a question of sorting through it.
Okay.
And
What about the
Kind
other?
of running a little late to be
Right, we have a, right,
decision.
correct,
If you
correct.
close the public hearing, you're gonna have to make a decision.
You have
within
62 days after you close this.
Yes.
So you're not going to make a
Okay.
decision tonight. You have
Yeah,
time.
we have time.
You have 62 days after you close this. So it's not like you're going to make a decision tonight. Just close the public hearing.
Okay. Russ, you have thoughts on
Just
it?
make sure that they're done with their comments.
Yeah.
I heard council say if we close the public hearing, we have 62 days to make a decision.
That's correct.
So we could close the public hearing and I guess address it next month.
Yep.
And then have a discussion on the case.
Yep.
That sounds
Yep.
good to me.
Okay.
Okay, so what we're discussing, if you've heard, is closing the public hearing, which means that right now is the last chance for the public to speak on this particular administrative review that we're discussing. Any further comments from the public at this time? Okay, yes.
I believe the neighbor's attorney put in another letter today that we haven't seen yet. So I would ask that if the public hearing is closed, he's giving you permitted to respond to the letter in writing.
Yes.
Thank you.
I just want to,
Do you want to give her a time frame when she can submit that? Any more, another week to submit the letter?
Wait a minute.
Respond?
Can you just acknowledge or read the two letters that came in that it was on the packet? This way they know that their voices are heard.
Yes, so we have received 2 letters. This is one.
There's two. No. There is in
Do
the
I have
packet.
another? Oh, in the packet. Right.
Yeah, from the neighbors. If you could just read them or, because they can't be here today.
There were 2 letters from the neighbors. Do we have those here to kind of briefly summarize?
I had a couple on my phone.
Yeah.
Yeah.
That's what she's talking about.
Can you just read them like what their voice?
Okay, so this is kind of in the summary. We acknowledge that although Cornerstone is operating a non-conforming pre-existing use, it has been there for a while and could, in fairness, be considered a special case. However, we are very concerned that the town would consider a retroactive permit for their illegal expansion. As architects ourselves, this is from Eric Bung, okay. As architects ourselves, we are dismayed that this would be considered, given not only the lack of compliance with zoning, but given the very unique character of the community and ecosystem of Silver Lake that would be affected. Please consider our community's concern. They start off basically just kind of introducing themselves, but that's the heart of the concern. And another one is coming from so Sarah Ivins and Stephen Rotondo. They've been Clinton residents for 25 years. This is saying for 20 years, Cornerstone has shown a lack of transparency with both town boards and neighboring communities in regards to the zoning law, and with the type of business they are now operating, they have expanded illegally and have shown a total disregard for town governance. Furthermore, Cornerstone's violation of zoning law shows a total disrespect for the town, the zoning board, and our community. For these reasons, Cornerstone should not be allowed to legalize their expansion retroactively, as this will set a very dangerous precedence for the town. We ask you, can anyone do this? Can we illegally expand our home into a hotel in the 10 years and ask forgiveness? So those are the 2 letters that we have received. There were also others that have come in before this, and we have this. So are there any other comments that we have from the public or others? So we would just ask, Jody, is a week enough time for you to review and draft this? So if we can get any further comments that you would have up to a week, yes?
Mr. Chair, as Jody pointed out, we have the burden, so the way it works typically is we get the last shot. So if they're going to put in more papers, and I have a copy of the letter that I've provided for Jody to take tonight. I have no objection to that.
Okay.
I want to have an opportunity to reply.
So fair. We will give.
When he's right, but I will. I understand.
Okay, so are you okay with a week and then within 2 weeks? So you would have another week for the response.
That's fine, as long as it's not another 20 pages long.
All right.
We'll just respond to records that hasn't been responded.
2nd for Jody, and then June 9th for Kyle.
Okay, June 2nd for Jody and June 9th for Kyle. All right, are we good with both of those?
Enough copies for everybody.
Yes.
Yes.
All right, further discussion on this? Again, further comments from the public? Anyone want to share? All right. Yes. All right, hold on 1 second. Yeah, come up.
Just one thing. If we're going to do that, I want consent from Kyle and from Jody that our 62-day period to make a decision goes from June 9th. It doesn't go from tonight.
Okay, great. I'm sorry, go ahead.
Does anyone in this room, in the middle, I heard a lot, and I understand some of the things I need to
Can you tell us your name?
Sandra, Oliveira.
How do you pronounce your last name?
Oliveira.
Okay. All right.
I was wondering if anyone in this room, because I keep hearing this comparison of between we getting permission to increase beds to help people that are dying, and we getting permission to build another bathroom, or to expand to a hotel in our home, or to build a pool house. Does anyone in this room stop to think we're talking about human beings that are actually dying? We're not making this up. It's on the TV, it's in your all politicians' speeches. Everyone talks about the epidemic all over the world. But yet, we compare expanding 30 beds to help people that are dying to expanding a bathroom. This, to me, is inhumane. I've been working in this field for a very, very, very long time. And I've never sat in a room, and I've dealt with a lot of communities, that actually compare the clients that I help every day. And don't get me wrong, they are not easy. They've been through so much, they are so hard to deal with. But I certainly don't look at them and see a bathroom, or a new bedroom, or a nice place to have outside of my house because it looks better in the summer when I want to sit out with my kids. We're not asking to look better, we're asking to help more people. And if clearly we were not needed and we didn't need to have those 99 beds or whatever, we will not have patients come in. And right now, everyone in this room that doesn't want us here because it comes down that they don't want us here, I just hope that in the future, their family members will not need us. Because we certainly will not turn them away. And maybe they will consider the approach that they took here today. It really bothers me that I'm in a room full of people and we are comparing human beings to bathrooms. It bothers me.
Thank you, Sandra. So both Jody and Kyle, legal counsel here is advising me to make sure we are understanding that the 62 days then will take place from June 9th when we have received that final period, that you would be okay with that. Kyle, you good with that? Jody? Okay, all right, great. So I would like to make a motion to close the public hearing.
Second.
All in favor?
Aye.
All right, so moved. Again, we want to express our appreciation for those who have come here. We know that you're sharing feelings that may be very dear to you on both sides, and it's not always easy for us to handle these. We have kind of the laws that we're dealing with, but also the emotions that we may have in expressing them. And I appreciate how well everyone has done this evening. Again, like I said, it's easy for us to get a little animated and emotional, but I appreciate the orderliness in which you have conducted yourselves and also the clarity in which you have expressed your feelings and your opinions. So thank you again for your time and for sharing with us to help us as a board make an informed decision. So again, thank you. We're going to continue on. You're all welcome to go. If you would like to see us and watch us review some minutes, you're welcome, of course, to stay. Yeah.
Good seeing you.
Take care of yourself. Right, get him home safe. Is it okay if we step into there to talk? This is cold out. Is it okay if we step into the court to talk?
No, we're going home. Everybody go home. Now I'm gonna go eat dinner. No problem. Yes. Oh, skip the food, thank you.
Hey, thank you, you're always there.
All the time. Anytime you guys need me, let me know. Crazy.
I told